All rise. The Supreme Court of Guam is on session. The Honorable Chief Justice Robert J. Torres presiding.
Affidavit counsels, you may be seated. Before we start, I just want to make sure, Ms. Williams, you're able to hear us fine with the assisted hearing?
I am, Your Honor.
All
Thank
right.
you.
All right, perfect. All right, will the clerk please call the case?
This is Supreme Court case number CVA24-001, SH Enterprises, Inc., Plaintiff Appellant v. Territory of Guam, General Services Agency, Department of Administration, and the Office of Public Accountability, Defendants Appellees. Appearing for Plaintiff Appellant is Attorney Vanessa L. Williams. Appearing for Defendants Appellee, Office of Public Accountability, is Joseph B. McDonald. Panel members consist of Chief Justice Robert J. Torres, Associate Justice F. Philip Carbolito, and Associate Justice Catherine A. Merriman. Your Honor, Attorney Williams reserves 10 minutes.
You may proceed, Ms. Williams. Justice Merriman just wants us to note for the record that the government of Guam also has a representative here who's not arguing but is present in the courtroom, Mr. Nathan Tennyson. Thank you. You may proceed, Ms. Williams.
Thank you, Chief Justice. Good morning, Chief Justice Torres. Justices, may it please the court. We're here today because the public auditor has taken the unprecedented action to debar a contractor. This never happened before. In this case, my client, SH Enterprises, Inc., is the first. There are two main points that I'm hoping to clarify for the court and why this was clearly erroneous and contrary to law. First, the main point is why the public auditor has no authority to debar a contractor under any circumstance under Guam procurement law. And second, why both the public auditor and Superior Court both erred in finding that the public auditor had authority in these circumstances. So with respect to the first point, this requires following the plain language of the Guam procurement law, of course, where we start, and specifically sections 5426, 5705, and then 5480B. I also want to look at.
I know it's clear that a petition for debarment was not filed here in accordance with 5426. But why shouldn't, Basil's protests be treated any differently than a petition for debarment? They both require filing with the chief procurement officer. They both allow for appeals to go before the OPA. And the CPO, the chief procurement officer, treated their filing as a petition to debar.
Well, for two reasons, Your Honor. First, if we look at the agency's decision, debarment wasn't discussed at all. And I believe that the precedent of this court is that the public auditor is reviewing the decision.
Well, they
before him.
didn't make a decision to debar, but they made a decision not to debar, right?
They didn't address debarment at all. And if you look at the procurement officer CPO's decision, it just addressed whether there was an ethical violation. No, there was no discussion of debarment or suspension. So it wasn't a decision to debar. The second reason I want to say why we shouldn't construe a protest on a solicitation or award as one for debarment and suspension is because we have different standards for review. So right under 5703, we have for petition to debar or suspend, we have 5705. And that says public auditor shall decide whether or extent to which the debarment or suspension was in accordance with statutes. In this case, there was no decision or debarment or suspension for the public auditor to review. And this is why we dispute that this was actually review authority over a debarment decision.
Is there a comparable provision for a review of 5425?
There isn't a separate section. So 5425 is interestingly only addressed in 5703. So 5425, I would say the parallel for procurement appeals under Article 12, it's 58703, subsection C, where it says notwithstanding 5425 of this chapter, no prior determination shall be final or conclusive on the public auditor. But and then for breach of contract and contract controversies, we have another standard. So for 5427 controversies, you have the standard of review under 5706, which
Yes.
says what the public auditor can do.
So, Ms. Williams, I was interested in your introduction in terms of, I thought where you were going. But in reference to, first of all, a bid protest, is debarment a remedy provided in statute, specified, I should say, in statute as a remedy in a bid protest?
Absolutely not. And thank you, Your Honor, because I think that makes the third point too, in response to Chief Justice Torres's question. The remedies are completely different depending on what type of controversy you find under Article 9.
And are there remedies at all specified under the procurement statutes? Are there, if your position is debarment is not a remedy specifically specified under statute for a bid protest, the follow-up question I have, are there any statutory provisions that lay out the remedies for a bid protest?
For a bid protest?
Yes.
Yes, Your Honor. I can't recall them at this point, but I know that in Guam procurement law, it says what remedies are available depending on whether it is pre-award or post-award.
Yeah, and then mostly is to arrive at a decision as to who is the most responsible and responsive bidder in a bid protest.
Correct.
All right, and so in a debarment petition, I'm just trying to understand before we even get to whether we treat it substantively as tantamount to a debarment petition, but are the process and the goals of a debarment petition as compared to a bid protest, are they similar, or is there a different purpose in reference to these two different processes?
There are very different processes, and that's exactly actually where I wanted to go with this. And if we look and we follow the statute for a protest under 5425, which is what we submit and what the public auditor in dispute, that's what they submitted. They have the ability to appeal. That's clear. That's well established. And then if you look at after the public auditor makes a decision under 5480, when we talk about the Superior Court's jurisdiction, it says the Superior Court of Guam has jurisdiction over an action between Guam and a bidder, offerer, or contractor, either actual or prospective, so very broad, to determine whether the solicitation or award of the contract is in accordance with statutes and regulations. So it make no sense that the Superior Court wouldn't have jurisdiction to address this debarment issue if that's permitted under a 5425 protest. Now, if you look at the parallel statutes for a 5426 petition to debar, and you follow that to section 5480B, again, talking about the Superior Court's jurisdiction, it says the Superior Court shall have jurisdiction over an action between Guam and a person who is subject to suspension or debarment proceeding. And so that's clear that it's anticipated the aggrieved person, the only person who can appeal a petition, a 5426 petition, is the person who's been debarred or suspended. And that makes sense that the Superior Court would only have jurisdiction to review that decision that has then been reviewed by the public auditor in the case that he upholds it or modifies it in a way that the debarred or suspended contractor is unhappy with.
But if we assume, and this is where I think the Chief Justice was, if we assume that the bid protests here can be substantively treated as the OPA did in reference to the facts of this case, as tantamount to a petition to debar and are guided by the requirements, what process in a petition to debar may have been left out if you go directly to the OPA and treat it as a petition to debar?
The processes that are exclusive to the executive branch, Your Honor. So that authority being solely reserved in the chief procurement officer, the director of public works, or the head of a purchasing agency. They're supposed to consult with the using agency, the agency that's going to be most affected by whether they can no longer do business with this contractor, if that's fair to Guam. And then, of course, the attorney general. They need consultation with the attorney general to determine whether there's cause. And so I'd submit that's akin to like prosecutorial discretion. So that has been divested from these from the executive branch by the public auditor initiating a debarment proceeding as on this appeal of a protest.
But the criticism that has been asserted that if that petition to debar is left to the executive branch, CPO, head of procurement agency, that it insulates the decision of that particular individual from further review if it is not allowed to have a further review from that decision. Now, that probably gets into the second point in reference to what does not to debar mean. But for purposes of just my question, how do we address that criticism? It's a very concerning criticism, and does the buck stop with the CPO, and that if there is corruption, that we just it's too bad, but there's nothing that can be done about it?
No, Your Honor. So I have a couple of responses to that question. With respect to it being insulated to review only by the CPO, we submit that's not correct because we also have anyone else, or we also have the AG's office, who, if there's an ethical violation, which they believe is tantamount to a crime, then they can prosecute that. That's not, I think that's not uncommon for the public auditor to point out these things which need to be investigated by the AG's office. The other avenue is the procurement policy office, another executive branch function. And where the public auditor made a mistake in his decision is he said, same thing. Well, what are we supposed to do if the CPO doesn't act? Then we're going to have this, alleged ethical violation. And they could have he said there's no reactivated public policy office, but there was a reactivated public policy office. And I believe that was in 2019. And this appeal or protest, I believe, was in 2020. So it's not insulated. The other response to your second part of your question is, how do we address that? If we don't like it, we go to the legislature. The public auditor is a creature of statute. That was the legislature's prerogative. We addressed the significant, extensive legislative history where there was some back and forth between our legislative body and the governor on whether this was appropriate, and they decided it wasn't.
Is the consultation with the using agency and the attorney general found in 5426 applicable even if for decisions that are made not to debar? I mean, it clearly is, if they have authority to debar after consultation with the using agency and the attorney general, is it possible that they can decide that they don't want to consult if they're going to make a decision not to debar? Or do we read that as saying anytime a debarment issue, whether to debar or not debar, they have to consult?
Your Honor, I'm not sure at this time. I've been reviewing the statute, and I know that when a petition to debar, a 5426 petition, as opposed to a 5425 protest, does trigger a process. And I believe that process does require investigation and a decision. So without, I apologize, not being able to identify the exact statute.
It's 5426A.
Right.
Specifically references consultation with the using agency and the attorney general, before they have authority to debar a person. And, my question was, can they decide, well, we're going to make a decision not to debar and therefore the chief procurement officer, and therefore we don't need to consult with the attorney general?
I'm hoping that answer is in the Guam procurement regulations, which I'm planning on looking back before my rebuttal, Your Honor. But I would say based on the executive authority that they have, it's possible that the CPO as a centralized procurement officer can make that decision without consultation with the AG's office.
Are you sure about that?
Yeah.
I mean, is that what 5426A says?
Well, 54.
I mean, doesn't that then make also the issue of insulation from review or criticism
Right.
much more suspect and heightened?
I may read that differently because it says that the Director of Public Works, head of the purchasing agency, after consultation with the using agency and the Attorney General shall have the authority to debar. I'm
Right.
not necessarily, I don't think that language suggests that a decision can be made without consultation.
It appears to me from this language that says the decision to debar can only be made with consultation. It's unclear to me, the language of the statute, whether the decision not to debar, they don't see that there's cause.
What if
to
they
debar.
disagree? What if the Attorney General wants to debar and the CPO doesn't? Can they still debar? I mean, there's different language for the Procurement Policy Office, which talks about concurrence, and that seems to be a higher standard. But here it's just consultation. It's not concurrence.
From my reading of 5426, I don't think the Attorney General, if they disagree, the CPO and the AG, I don't believe that the AG can independently debar a contractor.
Let me just ask before we go talk about the other issues. You talked about it being in derogation of the executive power of expenditure and managing the resources of the territory and inorganic. Can you expand on that?
Yes, Your Honor. So this was in reply to the public auditor's position, which I think keeps changing. You know, at first they said they have authority because this is review under, this is not a matter or initiating a debarment proceeding. This is a review, right? And then they say, okay, no, I have this authority and the Superior Court accepts this under 5703, under DMR. He has carte blanche. He can do whatever he wants as long as he believes it promotes the integrity of public procurement. Then their position, my argument was in response to their position that the public auditor is independent and cannot be required to consult or can do whatever the executive, the CPO, can do under his de novo review. He must also have the authority to determine a debarment. Now, I disagree with that on other reasons too, per statute and regulation, but the Organic Act question is, we only have 3 branches of government. And the public auditor's position is a creation from the Organic Act or authorized by the Organic Act to be created by the government. And it was in fact created, the legislature passed this, this was went into law, and now we have a creature of statute. And as a creature of statute, it can only do what it's expressly provided to do. Now, the CPOs of the statute says specifically, there's only 2 executive roles that can debar. That's the CPO and the Procurement Policy Office, both of which are active, are filled. And that makes sense, right? They're the ones who are actually on the ground reviewing these things and determining whether it's fair in the best interest of the territory. So the public auditor to say that it can, you know, if be under its authority under 5703 can just do whatever it needs to kind of rehabilitate the procurement process, contravenes the statute. Remember, so the Organic Act, the Act argument is he only has the authority that's under statute, and the authority under statute is under 5705, which says he can only determine whether or the extent to which the debarment was in accordance with law. Then if you look at 121 procurement.
Let's talk about that a second. So I want to understand what your position is on the scope of the OPA review on appeal of a decision to debar. Do you think he has the power to set aside the debarment entirely?
I think so.
Okay, what about increasing the period of time for debarment? If there, one year debarment was instituted by the CPO and he determines that it's more appropriate that it's a 2-year, does he have that authority?
I think so. And I think that is also based on 5480B.
Yeah, so if he can set aside the chief procurement officer's decision to debar and decide not that he can, that they not to debar after appeal of the decision, and he can also increase the period of debarment, isn't that deciding whether a company should be debarred? Isn't it akin to that? What's the difference?
It's reviewing, which he is authorized to do, as opposed to this case, there was no decision to debar, to modify or review, to increase or decrease.
I think another way that the question can be asked is, can the public auditor debar in the first instance?
No,
And so if there's a decision to debar by the CPO, and as you contend, the public auditor has the authority to review, they can decide whether that decision is correct or not, since there's already a decision to debar that's been made by the executive branch,
it can
or
just-
not to debar,
well,
or to debar, yeah, in this case.
he can decide it's correct to the extent where the language says it's in accordance with the statutes, regulations, and best interest of the government of Guam.
And so if he decides that it's not, then what's the result of that decision? If the
That
public
there would be
auditor,
no debarment.
there would be no
He can
debar.
set it aside.
He can set it aside, and then the territory can appeal that, and the Superior Court has jurisdiction under 5480B, just between the territory and debarred contractor.
What about a suspension appeal? If there's been a suspension appeal, can the OPA on review decide to debar?
I would say no, Your Honor, because when I'm looking at 5705C, it says shall decide whether or the extent to which the debarment or suspension. So if he's just looking at the suspension, he should just be looking at whether the suspension was fair and in accordance with law.
But if we're thinking about the powers on appeal, the suspensions appropriately before the OPA, as opposed to your argument here that there was no decision that was properly submitted to the OPA because there was no decision not to debar, that why couldn't, I mean, isn't debarment part of the range of sanctions that might be available in a suspension?
No, so those are two different remedies, and the decision can be on debarment or for suspension. And so I think if we have a decision for debarment, that's what can be reviewed, right, under 5705. And if we have a decision for suspension, that's what can be reviewed. Here, we didn't have either.
I'd like to move on to the other really substantive issue in this case, and the meaning of not to debar, and whether or not a decision not to debar, there's still jurisdiction on the part of the OPA to hear that decision. You argue that no, the OPA doesn't have any jurisdiction to review a decision not to debar.
Correct.
And the OPA argues that data management, if you read that decision, provides the basis in which to grant jurisdiction to the OPA. Is that your reading of data management?
No, it's not. I'm sorry, Your Honor, can you repeat the first part of the question?
So yeah, we're at the not to debar
Mhm.
now, which you argue that the OPA does not
Right.
have jurisdiction. And in the contention is it's implied, either it's implied in the statute, or if you read data management, which is arguably, as the OPA argues, is determinative, of this issue, that the OPA is vested with the responsibility to ensure the integrity of the procurement process. And how can it do that if it's not allowed to review decisions not to debar?
Right.
And so I'm asking whether or not you read data management that broadly.
Yes, Your Honor. So I don't read data management that broadly, and I'd like to return to that response. But first, in the question of why couldn't there be a review of a decision not to debar? Because review of a decision not to debar, the person who would conceivably, the person who's not being debarred, they wouldn't appeal that decision. Any other person, such as Basil in this case, who is the losing bidder, they are not an aggrieved party. They have no.
Is that a standing issue? Is that, we're saying it's jurisdictional, but nowhere in any of this discussion, is there any discussion about standing? Does that implicate a standing?
I do believe so. And I think this is where the public auditor got Guam Procurement Regulation 12-114 wrong, because if you look at that, it says the public auditor shall review actions between the territory and the person who is subject to suspension or debarment. That's the only action that the public auditor can review of a debarment or suspension decision.
I know you have 5 minutes left, but I wanted to ask one more question about the process in 5425, and when a member of the public petitions the chief procurement officer to take action to debar or suspend. There is a written report that's supposed to be made of findings of fact and the action taken. Was that done by the CPO in this case? I mean, you say, well, when Basil filed their protest, it really was not a petition to debar. And you said there was no decision ever made on not to debar by the CPO. And so was this written report provided?
Yes, it was, Your Honor. And that is in the record at OPA 183 to
But
184.
but that written report doesn't say that a decision was made not to debar?
No, it does not, Your Honor.
All right. And then under section E of 5425, it talks about, sorry, I'm not ED. It talks about the decision to debar being sent to the debarred or suspended person. And it says, or any other party that's intervening. There was no intervention by Basil in this case, or any determination of who might be an intervening party. Could you enlighten me who you think might be an intervening party in a particular matter?
So in this case, Basil wasn't the intervening party, it was the appellant, which we think was inappropriate. They didn't have standing to do so. But intervening parties, I think they could be other using agencies. I mean, I imagine.
I'll give you time to think about that while
Okay.
you have time for rebuttal. Thank
Okay,
you.
thank you.
Oh, yes, Justice Merriman.
Yes. I'm sorry, Your Honor, I can't hear you.
I'm concerned about this court's jurisdiction. Isn't this a moot issue now? The contract was supposed to be a 3-year contract awarded in 2020. There's no remedy. Isn't it all moot? You can answer that when you come back. Thank you.
Thank you.
Mr. McDonald.
Buenas, Chief Justice Torres, Justice Carbolito, Justice Merriman. May it please the court.
Can we start with how is Basil an aggrieved party entitled to appeal?
When you look at DFS and its explanation of aggrieved, what it's really talking about is standing. And if you look at 5426F, Any person may petition. So in the
But it doesn't give the right of appeal to those petitioners in 54-26F.
this is exactly where I wanted to go. Under 5703, it states that
To determine any matter properly submitted.
properly submitted matter is subject matter. And the subject matter arises whether or not it's legitimate subject matter is a separate issue. What we're talking about in 5703 is exercising subject matter jurisdiction upon exhaustion of remedies. What was the remedy? The remedy sought by Basil with the CPO in substance was a petition to debar. Now, here's the crazy part.
What about the argument that there was no decision to not debar? There wasn't even a decision to debar or not to bar, to debar. So
I guess if I ask a question and it comes back with a non-answer, that's a no. And it's still an administrative exhaustion because I did in fact take advantage, and let's remember aggrieved 14 days. I'm charged with knowledge. Now I have standing. I go to the CPO. I get a 5426C decision in substance. Now I have a matter properly submitted
but they're
because I
not
have a
the ones
decision.
who received the 5426C decision. They should have been entitled to under 5426 a report of what occurred. But they're not the one. The 5426 decision is given to the person who's been suspended or debarred
Which didn't happen.
because there was no suspension or debarment.
Correct.
So there was no 56C decision. A 5426C decision.
I think there was a 5426C decision in the context of a petition, if you treat it like a petition.
But if you look at the petition, does it allow, I mean, just even let's look in, I'm assuming it is. That let's assume that what was actually filed by them was a petition for as any member of the public can do for debarment. And they filed that petition. And so where do you read in 5426 that a member of the public who petitions the CPO has a right of appeal? F allows any member of the public to file the petition, and they're entitled to a written report of the findings of fact and the action taken. The decision that's referenced in 5426C is a written decision to debar or suspend. And it informs that person who's been debarred or suspended of their right of appeal.
Well, the decision under 5426E says that it can be taken to the public auditor. And that decision was rendered by the CPO who actually
So you're
informed
saying
the appellant,
So you're saying the decision under, it does say in finality under subsection C or F. So you say the written report under subsection F is a decision, the report is a decision that then the appeal can be taken to the public auditor.
Yes, Your Honor.
Right.
That's precisely correct. And let's just, I'd like to go through this exercise if the court will allow it. Let's just go through what happened here. Maybe it's the eve of contract expiration and we need to get this thing out. So what we're going to do is we're going to deny this and move it along. What if instead of denying, there was a substantial interest determination under 5425G? There's two subject matters under 5425. One is this aggrieved person making a protest and having the decision. And the other is under G, which is the substantial interest determination. Then what you trigger, and the way to read 54, I think all of 5425 and all of these others is really from the lens of the protester. from the lens of the protester. So if you look at 5425G, it almost doesn't make sense until you realize at the end, it says there, you have 2 days notice to protest a substantial interest determination. So if we were to go back in time, when this was coming up and had that been made, then you have a different story. Then you have a confirmation of a substantial interest determination. Why is this important? Because the 2 days triggers the injunction, the stand down order under 5425G. If you can make this determination and it's confirmed, the award can proceed forward. So let's actually bring this all the way back, because this is where this really is important.
How does this relate to the facts of this case?
I'm just trying to go through and make sure that we understand how it could be viewed that this is arising within the context of a DMR type situation. And the DMR, the wisdom of DMR was it does not go back to the CPO. So what we're saying here that's suggested, DMR says you don't have to go back to CPO and you can fashion a remedy. And when I was preparing for today and I asked the public auditor, like, what do you think is important to emphasize? And he said the context.
Is this part of the record?
This is part of the record. Well, not that discussion, but I'll read the record right now. This is 521. ER 521. And at the bottom, do you recall that when your attorney was questioning you on October 6th, one of the questions she asked was whether the Hakubotan building was vacant, and you responded, yes, it was vacant. But if there is a public or private interest to use it for a good cause, that you would be willing to donate it. Do you remember that? Yes. And is it still your stance today that if there's a public or private use for it, a good cause, will you donate it? She has the same thoughts. I'm sorry. She has the same thoughts. The same thoughts to donate it? Yes. Same thoughts to donate it.
How does that relate to jurisdiction?
The public auditor is constrained to act. Constrained to act. Let's remember how this really works.
Yeah, I want to go back to, because and looking at our discussion when you pointed out that 5426 E talks about a decision under subsection C or subsection F, and subsection F deals with the public petition for debarment is final unless an appeal is taken to the public auditor in accordance with 5706. So there's a separate reference to 5706. And the 5706 talks about, the aggrieved person filing his or her appeal. And so, we get back to the question of whether Basil was an aggrieved person. And then 5705. We all know there was a Scribner's error and it shouldn't be 5706, that cross-reference. That the public auditor decides the extent to which the debarment or suspension was in accordance with the statute that's in there. So you still have to, it seems, have to have a decision for debarment or suspension.
I mean,
some decision, whether
decision.
Yeah, and the argument is there was no decision made at all. Although your argument as well, a decision that doesn't take a decision is a no, is what you're saying. That's your position, that even though they didn't address the specific issue of whether to debar or not to debar, that was enough to trigger the provision for the public auditor to review that.
I think it's deeper, and we go back to DMR, because DMR actually allows you to make determinations of fact, allows the public auditor to make determinations of fact, and also to implement correctives. That's the wisdom of DMR.
But that assumes they already have the authority to hear the matter. I mean, I think, I don't think that we can read DMR as broad to say if there's no authority or no jurisdiction for the public auditor, he would still have that ability under an implied authority. The implied authority comes from the authority that he possesses, and that's not expressed within that is how I read it.
nor is it expressed in DMR. The issue is whether it should be overly constrictive, whether the reading is overly constrictive. And this is the issue, right? The public auditor, and this is where I would like to have gone earlier, the public auditor being a creature, created from the Organic Act, public official and body, but subject to the parameters of the legislature, subject to the parameters of the legislative acts. So there's no express,
Can you address the argument of inorganicity with, could the legislature take away executive powers and transfer it to the public auditor if they wanted? She argues that that the exercise in this case of the power to debar is in derogation of the executive powers of executive and managing the resources of the territory. Let's assume that the legislature wanted to give that power, as there were attempts to do so in the past, the power to debar to the public auditor. Could they do that? Or would that, address why that would?
a search of the Organic Act fails to show anything about debarment powers of or procurement powers of the executive. But we do know that the legislature appropriates, sets the contours of government, and the executive operates within those contours. And that's really what's going on here. Because in creating the office, it said it was independent. The issue with the separation of powers is not invading. It's about checks and balances. Let's remember the two primary purposes for the public auditor. One is to check on the health of programs and policies and initiatives of the government.
But how does it go about doing that? Does it do that in terms of its review authority as specified in the statute, or does it, or is it capable of doing this in enforcing the statute?
I would say under DMR,
I mean, if we're going to address the constitutionality of the scope of authority, the question in my mind was the public auditor created to review decisions stemming from procurement disputes?
absolutely.
Or does it, or is it vested with authority to enforce the procurement statutes?
I think it's both.
Well, wouldn't that be an executive function for enforcement?
Only if it is, and it's non-reviewable, then that's the result from this case.
So it's a review authority vested in its responsibility to review decisions regarding procurement awards. Can you cite to me any statute that says that the public auditor is vested with the power to enforce the procurement rules and regulations
Well, I think
on its own without it being a case or controversy in front of the office in deciding a dispute on a procurement issue?
I think this is why we go back to DMR, right? We go back to DMR because it's a derived rule about the extent to which the jurisdiction can be exercised.
Yeah, but as the Chief Justice pointed out, DMR at least was able to point to a source of authority that implied the general responsibility that was derived that gave the public auditor the authority in which to act in that particular case. I mean, it wasn't done in an abstract that there's nothing I can point to unless let me just decide how I want to decide this.
I'm not sure that's the way it worked. I mean, really, again, what we're
But
talking.
that's what you're suggesting.
What I'm suggesting is if the agency level makes a mistake and that subject matter is brought in front of the public auditor, what are the parameters to correct this?
Yeah, but you're assuming that the agency acted within its authority as specified by the statute, which public auditor as a reviewing organization would then have the authority to decide whether or not it was done correctly or incorrectly, because it has a standard in which it has a statute in which to in which to decide whether or not a correct decision was made or not.
Well, that's definitely arriving under 5705. That's definitely arriving under 5705.
I'm not
Again,
understanding what do you mean?
so I guess the hangup here is that if you look at 5703, it's when they can protest. Once that protest, whatever that controversy is, in front of properly, subject matter in front, exhaustion of administrative remedies, it's a decision, it's written. If the agency makes a mistake, the legislature intended that the public auditor correct that mistake. That's the only reason to have this review and also to have the power in DMR to fashion the remedy.
Yeah, but the decision, the review doesn't stop at that point. The consideration is then does it have the authority to take the extra step of ordering a remedy that may not be provided in statute? That's what we're talking about here.
And you insist that it has to be a mistake. I mean, what if there was a conscious decision recognizing that there might have been some transgressions committed by a vendor, but there were reasons why the chief procurement officer decided not to proceed with a debarment? That the benefits of continuing in business might outweigh the impropriety and the harm that might be caused to the government by debarment of this particular contractor.
I think that's exactly what we have here. That's exactly what we have here. And the context that it was read in is this is a charitable donation.
No, but then isn't the decision by the public, the chief procurement officer, why isn't he best suited to make the decisions about that? Does the public auditor have access to the information in terms of being able to evaluate the repercussions to the government of debarment of this particular contractor vis-a-vis the benefits that might be obtained by allowing it to remain a competitive bidder in the process?
I believe the public auditor is actually allowed to subpoena and to inquire further, and the public auditor does engage in colloquy and questioning. So yes, that's there.
Yeah, but what if he doesn't do that? I mean, presumably the chief procurement officer is in the position to best understand the procurement process to make a judgment of the repercussions that would result from debarment of this vendor.
Well, I'm not, I mean, I'd like to get into Chevron and all of that, but whether the agency is best suited is I think a valid discussion, but the issue from a 5425 protest standpoint is whether or not I'm sufficiently aggrieved to bring subject matter into the OPA. And
Well, I think that, and that's why I asked Ms. Williams to try and describe the process in terms of petition to debar and a protest, and to file a bid protest. I mean, the tools available to the chief procurement officer may not necessarily be available to the OPA in considering the dispute and arriving at a decision. The OPA maintains that I don't consult with the Attorney General's office because that interferes with the independence of the office, and rightly so. But that goes to its review process. And in reference to a debarment petition, the reason why the legislature may have decided, if that's how it's going to be interpreted, that it ends with the CPO in a decision not to debar, because it consults with the agency affected, it consults with the Attorney General, and it arrives at the best decision that can be made based on that input. So if there is some allegation of fraud, corruption, there are other tools, remedies that addresses that, and it's not within the procurement process.
well, then you nullify the authority of and the jurisdiction of the OPA.
That's
To-
what this case is about.
But how do we nullify it? If the OPA still has the right on it to review a decision to debar?
Well,
Right?
if you.
And there's been consultation. I mean,
I think I'm not following because on the one hand, Justice Carbolito was saying, you know, and York, and so those are,
well, no, I think we both realize that OPA has a role to play in reviewing a decision to debar. Where it's not explicit authority is the OPA's decision to review a decision not to debar. And if a decision is made not to debar and there's a requirement of consultation, if we read the provision with the Attorney General, with the using agency, there are remedies, other ways that you can ensure that the decision's been appropriately made.
I mean, I don't think Chief Justice, I don't think I disagree with much of what you said. The issue is how it comes before the OPA and what does it ask for and what kind of facts need to be put in front of the OPA to make this decision. And if the subject matter includes something, I think what we're forgetting is that one of the wise justices asked, well, you know, what if there was losing my train of thought, but the negative of a decision is the same thing as a positive of a decision, I would say, especially in the context of a checks and balances.
Let me ask this then, maybe it'll help elucidate. We had talked about, Justice Carbolito pointed out, about the process of consultation with the Attorney General, and it appears that that was done in this case. But what if the Chief Procurement Officer did not consult and didn't have the Attorney General's concurrence, or the Procurement Policy Office, which has to get their concurrence in order to debar, didn't have any concurrence whatsoever or consultation on their decision not to debar, and then and you say it comes up to the Attorney General. So the Attorney General, I mean, it comes up to the OPA, and then the OPA does not consult because they say, I don't want to consult. I shouldn't be required to consult. I'm independent from the Attorney General. So we have a decision that's made to debar an individual without any consultation or concurrence with debar contractor, without any consultation or concurrence from the Attorney General.
There's nothing in the statute to divest jurisdiction over the question, even in the absence of consultation. What triggers the subject matter jurisdiction is the decision. And if that decision is faulty, then let's play that out.
The decision contemplates concurrence, doesn't it?
The decision contemplates concurrence.
So if there's no concurrence at all, then you're saying, but the OPA then can make that decision even without concurrence. So there's a gap there. Right?
There's a gap. And it's,
I mean, doesn't it make sense that the Attorney General be involved in that process to evaluate as well, you know, what implications are for the government?
to the extent the Attorney General does provide counsel, as we know. So we get to the same place, sort of with or without the Attorney General.
But there was consultation here. Right?
That believes to be a part of the record. And you know, in common practice and custom, we know that the CPO is constantly talking to her lawyer. So there's going to be some consultation. And to do it this way is how they thought to do it. What they did, though, was still create the subject matter under 5703. Properly submitted. It's the process. And then you look to what the OPA does from a checks and balance standpoint, and let's see if the substance is there. And if we decide to go along this route, are we providing process that is due?
But there's a difference, Mr. McDonald, between just submitting a decision and deciding whether that decision is correct or not correct, or whether there's jurisdiction or no jurisdiction. I don't have any issues that decision should be submitted, can be submitted, but that doesn't end the analysis. If it is determined that there is no jurisdiction, then the corresponding result should issue. But submitting a decision of the CPO is not the issue. It's deciding whether or not there is jurisdiction or not at its inception, and if there is, whether it's correct or not correct. So I'm not understanding your explanation.
I think probably this is where this wise court will come down, because if we're stuck in 5425 land for a 5426, when we know something is wrong and we've taken jurisdiction under 5703, then it's unreviewable. And if that's the law, that's the law. But but you still have the subject matter that was actually asked at the agency level, and the administrative remedies were exhausted in the context of a protest. In the context of a protest. And as was stated by this wise court earlier today, well, doesn't that always go into a decision to award? Isn't there always implied a question of responsibility?
But the question of whether to award is a different question than the question of whether to debar.
It's still a responsibility inquiry
Let me
at
ask,
its roots.
is there any other jurisdiction that allows an appellate agency in the first instance to make a decision to debar?
Haven't done the research, but I imagine there is.
Isn't that important to consider?
That's why we come to this wise court. But I imagine there is, Your Honors, because you have, under other procedures, an expedited review process that is sometimes reviewable and not reviewable. And indeed, we have that in the statutes. The legislature has been passing under 5425.1.2. We see that. So if you look at the body of law that's unfolding, they're trying to help with the jurisdiction, at least at the review level, and because of the checks and balances, implement some correctives. And so what we have here is something that the public auditor could not unsee. And what are we going to do? And can we actually use the jurisdiction? We are constrained to act in the integrity of the procurement system and the policies in 5001. So that is where I think the fighting ground is on these checks and balances.
Well, I respectfully disagree. I mean, the equities may all be in your favor, as you state, but if the statute doesn't specify, as argued, that the public auditor is a creature of statute, and if the statute does not specify the authority and the jurisdiction, all the equities is better suited to present to the legislature than to this court.
Oh, we think it's there. We think it's there because of the decision.
Now, in this case, SH was a respondent. It wasn't the chief procurement officer of the agency, which would be, what would normally be the case if a decision to debar is done, because they would be the appealing authority, obviously, if a CPO makes that decision. Did that make any difference? And it make any difference or?
In affording process that's due,
Yeah.
it's notice and opportunity to be heard. Since there was no debarment, there's no, in fact, infringement of any right for which the process is affecting. It was only at appeal when they became an interested party. Yes, that's correct. Now we're sitting here with a situation that's a faulty decision of the CPO, and the OPA is constrained to act in the integrity of the procurement system. So if the court says there's no jurisdiction in that situation and it's unreviewable, then that's the law. But we think under
But
DMR.
why do you say it's a faulty decision of the CPO to make the determination in this case?
Well, procedurally, notice those things, that this thing was actually happening, that didn't take place. They went straight to the protestant. So they too treat it as a protest, wisely so. But in the end, what they're giving is in substance a 5426C decision in the guise of a 5425C decision. And that's the subject matter that now comes before the public auditor. And it's that decision not to debar that actually becomes the subject matter. And I'm about to run out of time, Your Honor.
All right, thank you.
Thank you.
Yeah, Justice Merriman has a question, please.
I'm gonna ask you the same question as Ms. Williams. Isn't this matter all moot at this point?
Capable of repetition and evading review. So there's an exception to mootness. And we would hope that there is some elucidation of this point.
Well, there are, in response to Justice Merriman's question, there are two cases, two protests that were filed. Isn't that correct?
That's correct.
So one is still pending to determine whether or not an award was properly made.
I think one is pending to determine whether or not there was a actual, the judge kind of just bootstrapped the issue in. The first one was whether it was correct that there was in fact a favor. Once that was decided, the OPA did an OC.
No, but
OSD.
my point is that there is one case pending that there is left to be decided whether or not the procurement of services should be awarded to SH Enterprises. And if the 3 years has expired, then, you know, maybe jurisdiction is questionable. But the case in front of us has to do with whether or not debarment is appropriate or not. And that has nothing to do with the expiration of a 3-year contract.
Again, I think in looking at jurisdiction that's exercised to for the integrity of the procurement system, you kind of still get to the same point, which is, you know, again, it's backwards in a way, with all respect to the trial court, because this is the actual debarment that's coming up without actually deciding whether or not there was in fact a favor. So maybe that's the instruction, is to mandate for further. But it really kind of, the discussion we're having now doesn't matter, because whether it comes up with it or not, this wise court will tell us, yeah, you had the jurisdiction under 5703 to go into 5705 to do a 5426 when it was a 5425.
I did have two other questions actually that you triggered me, and Justice Merriman's question on the mootness also triggered this. First of all, the Superior Court, when it's made its determination that it could, OPA had authority, relied on the de novo review of the OPA and said that vested the OPA with jurisdiction if a decision not to debar is not properly submitted to the OPA in the first instance. And so it said, well, you know, even if this decision, which didn't reference debarment, was not submitted to the OPA's de novo review vests them with jurisdiction. Is that a proper basis for asserting jurisdiction as a standard of review? I mean, it seems that standards of review indicate the deference that a court should give the decision below, but it only can give that deference if it has the authority to review it in the first place. So I don't see, I think, how the Superior Court can rely upon de novo review by the OPA as the basis for the OPA having jurisdiction.
De novo review by the OPA looks at the question anew, and then the standard review from the trial court is whether it's.
Yeah, but how does that give jurisdiction to the OPA? The OPA, there's no doubt, has de novo jurisdiction. I mean, de novo review, but how does that standard of review automatically give the OPA the right or the jurisdiction to review it?
I guess it depends if we believe that the subject matter is positive and negative, yeah. Right? And is it a decision to and a decision not to? Does it actually have that authority? It's like any other tribunal. It looks at whether it can and also whether it can't. And so that I'm not sure we've articulated law that says you can splice it that way, other than strictly construing, which we're asking the court not to do.
And then the other thing is the OPA characterized the issue as one of mootness. They basically said that because it was capable of repetition, but evading review, the OPA can assert jurisdiction over that claim. But can an exception to the mootness doctrine of evading review expand on a court's jurisdiction? I mean, that seems to be a grant that's provided for by law, and mootness is a justiciable concern.
Yes, I think, again, this is one of the keys, right? That gets us to actually exercise the jurisdiction is, can we get over that hurdle that it's moot? Now that we're in there, is there actually the subject matter?
Yeah, but it seems like in both instances, they made the determination, the trial court, de novo review, therefore we have jurisdiction. And OPA saying, well, it's going to be moot, so we can have jurisdiction. And it enlarged jurisdiction based on mootness, as the trial court found it had jurisdiction based on its de novo power. And both of those concepts seem a little misplaced to me, that you can rely on de novo review or mootness to expand on jurisdiction.
I think this is where we have to be careful, and whether it's properly submitted by an aggrieved party in the first instance, again, invoking that review jurisdiction. And then once that review jurisdiction is undertaken, is the actual subject matter there?
Okay. All right. Thank you.
Thank you, justices.
Yep. He had 6 extra minutes, so I'll give you 8 minutes. You had 5 remaining. I'll give you 8 minutes.
Thank you, Chief Justice. I'll start with addressing each of your questions that you left me to ponder on. So first, with respect to Justice Merriman, the mootness question, I do agree with Mr. McDonald on the position that it's capable of repetition but evading review. And to Chief Justice Carbolito's concern about, well, isn't there another matter pending? The decision pending in the other case that's currently with the Superior Court was a separate decision from this. So in that decision, the public auditor was actually reviewing the decision that the CPO gave and said, okay, I disagree. There was an ethical violation. And that concluded that appeal. And then he deconsolidated the appeals. And that was the decision we appealed that's still below with the Superior Court. And it's just, I guess, by happenstance that we're hearing this later decision first before this court. And that decision is, can the public auditor issue an order to show cause to debar and debar a contractor? So that was after he had already reviewed the 5425 protest. With respect to the question on who is the interested party are the people who are aggrieved or affected. Now, who's affected by contracts with the government and contractors? The government. So I believe the aggrieved parties would be the other executive agencies or any instrumentality who was concerned about the fairness or propriety of any specific contractor being able to continue to do business with the government. And as I was reviewing the Guam procurement regulations, I think there is indication of some support from that, because there's I forget the site, but it says that all other executive agencies have to respect the decision on that debarment, so I believe that's why we can consider them, they're interested parties, right? They need to be able to have a say. Now, going to the question of, let me see. And the question on the process for, I believe this was Justice Carbolito's question, for protesting a word versus petitioning for debarment. That citation, the guidance in the procurement regulations can be found in section 9101 and 9102. With respect to the remedies that can be imposed on a protest under 5425, that's under section 5452 of Guam procurement law, and debarment is not in there. I wanted to address some of the questions that the court posed to Mr. McDonald in terms of, how is based on an aggrieved party? They're not an aggrieved party.
Well, what about 5426E, which provides for an appeal to be taken of a decision under subsection F? And subsection F, of course, if you look at subsection F, it talks about the written report being made of findings and fact and the action taken when a member of the public petitions the chief procurement officer. So there's a specific reference to that decision under F being final and conclusive unless an appeal is taken. And doesn't that seem to suggest that a member of the public who gets a decision can take an appeal?
Without context, maybe, but there's lots of context to find otherwise. So if you look at when we're talking about subsection F, it says this is only about who may petition the CPO for debarment. When we
Correct.
look at subsection E, it says a decision or appeal may be taken, but it doesn't say who, right? So this is where we go and we look at context and we look at sections procurement regulation 12114, which I previously.
But why would it
referenced.
reference then F? I mean, because if a decision under C can be taken, I mean, that's clear. But why would they put a decision under subsection C or F? Why would they have to repeat that language if you feel that it's only limited to a person, a decision under C that's capable of appeal? I mean,
I'm not sure I understand, Your Honor, the question, in terms of
well,
what the difference between.
the
a decision-
finality of decisions references both a decision under C
Oh.
and a decision under F, right?
Right, okay.
Right? And so why, if you're saying, well, it has to be taken in context, and I mean, I presume this is what you are arguing, that it's an appeal of a decision under C. And that's the only appeal that can be taken. But then if that's the case, why would they put the or F language in there?
Because a person could still be debarred by a decision under F. They would be the aggrieved party. They're the person who has standing to appeal.
So
to
you're
the
saying
public
that's a
auditor.
separate process, done with when a person petitions the chief procurement officer, that's different than the chief procurement officer giving notice to the person under the A provision.
That's correct.
Okay, I understand.
Thank you. So we can see why, or I believe I already touched on why we can't consider Basil an aggrieved party under 5426. I also wanted to reference that if we look at the model procurement code, which we know the Guam procurement law was based on, and I believe DMR itself says we can look to the commentary of that code for and that was adopted as the legislative history for our law. And you look at the code parallels for 5426F or 5426 and 5705, they equate an aggrieved person who can appeal to a debarred or suspended person. So that's another reference we can look at or context to determine that Basil is not aggrieved.
Is there any other jurisdiction that allows debarment in the first instance on appeal?
Not that I'm aware of. I admittedly, I only looked to federal law and found none.
Did you have the opportunity to review the provisions of the model penal code if it allows an appeal from a decision not to debar?
Yes, I did, and it doesn't. That's where those provisions, the sections, I forget the section, of the model procurement code, but they track the language of 5426 and 5705. So I wanted to get in closing, what I think that's happening here is the public auditor is using the ends to justify the means. He sees something that wants to remedy something, but that the statute simply does not allow. Their reliance and representation that the public auditor was created by the Organic Act is just not true. The language of the Organic Act says that the government of Guam may establish an office of public auditor or office of public prosecutor, while also providing that they may remove such offices. So the public auditor wasn't created by the Organic Act, it's created by statute. And where the statute says it doesn't have the public auditor can only review in this way, it can only review a debarment decision, and it doesn't give it the authority to initiate debarment in the first place, then he simply does not have that authority. Thank you, Your Honors.
Thank you. Any further questions?
None.
All right, thank you, Mr. McDonald, Ms. Williams. The court will take the matter under advisement. We will issue a written opinion and will now stand adjourned.
All rise.